So, in this lecture, we are covering easements. We're doing the first of two lectures on easements. The first being what is an easement. So, we'll look at the difference between an easement and other forms of ability to be on land for certain purposes. Again, similar to what you would be doing with a lease license question, an easement standalone question would require a lot of exploration around that. You'd have various parties using specific rights on land that you would have to ascertain as to what type of easements they would be, and then how they've been created and how to attach them to the land. We aren't going to need to cover it in depth in terms of assessment. The only area that it will come up in for you would be as regards an easement situation within a registered land problem question. So with registered land problem question, it would be best that you show knowledge of what type of easement you're dealing with. The best way to do that is always if you've got a case that supports what type of easement that is, that's good knowledge. And then obviously the formalities aspect we'll need to run through again. So you're not having to address this using the language of analysing it like an easements problem question, but you do obviously have to show some comfort around the fact that you are exploring and advising as regards estates and interests in land that are proprietary, meaning they are fixed and attached to the land itself and not personal. So we'll explore that again briefly so that you know what it is you're doing in a registered land problem question in this area, and then cover the information you would need to cover to have some knowledge of easements. So what I'd like to do in the session is look at the difference between easements and other types of holds on the land. So profit à prendre being that ability to take something from the land as well. So not just the ability to be on the land, but to take something from it. That also being a proprietary right in land. And also the difference between an easement and a license, one being proprietary and affixing and attaching somebody to the land, and the other being a mere license or permission to be on the land in some way that is easily revocable. The key focus of any session like this would be to explore the essence of an easement. So that would be key if you're dealing with this as an assessment strategy. Obviously we're not, but it's a very important part of easements as a discipline. And then we would look at the difference between law and equity again, which will matter for you guys when you're thinking about formalities. So an easement versus a profit à prendre. So it should be fairly clear. We have covered it in passing a few times. This notion that an easement is a right over land that affixes and attaches somebody. It's usually permissive in nature. It's the ability to use land in some way, as opposed to restricting it or fettering it the way a covenant would, which is where we're headed next week. So that means that the easement is permissive in nature. It's allowing for land use. It's usually in relation to access, so a right of way. And we'll look at a few different types of permissions that have been granted previously. We look at rights of light, rights of air, etc. And we look at that slide of previously recognised easements. The difference then between that and what is recognised as a profit à prendre or profit is that the profit is to be taken. So literally a translation from the French there, it's a profit that is taken or something that is taken from the land. Now profit doesn't mean money in this case, it means something that is a gain. So we're thinking about fishing rights or taking wood, taking something from the ground, taking berries, you know, all of those sorts of things that could be taken from the land as an asset. So an easement or a license would allow somebody permission to go onto the land, and then when they're on the land they may have a higher interest in the land if it's a profit over a license, to be able to actually take something from the land. So when we looked at licenses previously, we looked at a bare license, permissive. We had contractual license, so coupled with some form of consideration, and we had a license coupled with a grant, and that A license coupled with a grant is the permission to take something from the land. It would be better if there was an easement because that's a proprietary interest, but a license coupled with a grant is the strongest form of license you could have because it's attaching itself to a property interest. Therefore, we need to be able to establish when we see somebody using a right on land and it's not their land, whether they are just there through some form of permission that we could revoke and remove them from the land, so some form of license, or whether their hold in the land has become an easement, whether their hold in the land has become something that affixes and attaches them to the land. So an easement, therefore, being proprietary in nature, it affixes and attaches our claimant to the land itself. It's a hold that they would then bind future purchasers with. It's not revocable. We can't just stop somebody from using it if they have established it as a proprietary right. And hopefully by now you're starting to understand that there would have been hopefully some formalities behind that and registration. A license, therefore, being the different way of being on land with perhaps some form of permission, but it is able to be revoked. So it's a personal interest, it's for the benefit of the person themselves rather than to do with the land, and it can be revoked. You can ask somebody to leave if there's a contract we might be in breach, but generally it's quite easy to revoke a license and remove them from the premises. Consider them trespassers, give them reasonable time to leave. But how do we as land lawyers then go about determining whether somebody has an easement or a license? We would have to, in an easement problem question, run through the criteria or characteristics that you would need for an easement. The same way as we did with determining whether something was a lease, you would have to conduct the same assessment or analysis of what the characteristics are for an easement. So there's a few different steps to go through. Is it an easement? How was it created? And then has it been formalised? So the essence element, that is it even an easement at all? The requirements come from a key case in easements referred to as re Ellenborough Park. So that's the case in relation to the essence of an easement. It gives us what's known as the Ellenborough Park criteria. And I'm going to break each of these down because the language usage is a little bit intimidating. So we require a dominant and a servient tenement. Hopefully you will know or recall from whenever we're looking at the LPA that a tenement just means a piece of land. So we had corporeal and incorporeal before, things with body, things without body. Tenement just meaning a piece of land, so therefore being corporeal. So we would require a dominant and a servient piece of land. We'll look at what that means in a moment. The dominant and servient tenements must be owned or occupied by different people. Quite obviously it's not possible to have an easement over yourself. That's just you using your own land. So we need to articulate who the separate parties are who could have the kind of dominance or the servience, benefit or burden of the easement. The right must accommodate or benefit the land itself, so it's not seen to be something that's personal in nature, otherwise that would be akin to a license. So we would look at whether it adds use or value or some form of ability to enable something to happen on the land rather than for the person. But some of the case law in this is very grey, to be honest. And the right itself must be capable of forming the subject matter of a grant. So to form the subject matter of a grant, to be able to be written out in a grant or in a contract or a document, we would look for it to be definite. We'd have to be able to see the path, quantify it, map it. We have to be able to ascertain something that is real and true. And we'd have to have a capable grantor and grantee because this is contract. We'd be looking for capacity as well. So we'll run through each of these in turn and I can explain them hopefully better using some visual prompts too. So the first requirement being that there should be a dominant and a servient piece of land. Dominant tenement is the piece of land which benefits from the easement. So the dominant tenement is the one that is kind of superior because it has some benefit of an easement being used. The servient therefore being burdened by it. So the servient tenement kind of having to suffer or deal with the fact that this easement exists over their land. So what would that look like if you were to think about person A on the left and person B on the right, with a right of way crossing B's land out onto potentially a main road or wherever it leads to? A's land would have the benefit of that, therefore A's land is dominant. B's land is burdened by this because they have to kind of endure the fact that A is going to wander across their land, so B is burdened. So we have benefit and burden on the land. We have a dominant servient, dominant tenement on the left and a servient tenement on the right. So we have two separate pieces of land, one benefiting from an easement and one being burdened by it. The next criteria that we see in the Real Ellenborough Park case is that those dominant and servient tenements are then obviously owned or occupied by different entities or different parties. It is not possible for you to be able to have an easement over yourself. So if one person owned both of those plots of land that I showed you a moment ago, it wouldn't be them having an easement, it would just be them using their own land, and therefore that's not an easement. It's just them exercising the rights of true ownership. However, we don't have to deal with two separate owners. We could be looking at A and B as technically landlord and tenant, so it would be possible for a tenant to have an easement over a landlord's land usually, or a landlord to retain access in some way and have a right of way over their tenant's land. So we could have landlord-tenant separation there. So what that would look like is quite easy to address because we have separate names there. We have reference to A as one party owning or occupying that land, and B as a separate party owning and occupying that land. So we can see that the dominant tenement is owned and occupied by A, and the servient tenement is owned and occupied by B. So we have separation there of ownership or occupation. Tick to the second criteria in Ellenborough Park. The third characteristic is the most difficult in some ways, in that what is being asked for is that the right itself accommodates or benefits the land. So it has to be of use or add value or enhance the land in some way, which is quite a difficult thing to articulate, because if you're thinking about what would benefit land, it's obviously going to benefit people. And if it adds value to land, it's because people are able to do more with it, and it makes them happy, or they can play a sport or do a thing on it that comes with it. So that would naturally add value. So some of these cases can be hard to reconcile. The idea being that because it's a property interest, we're looking for it to benefit the land and not just simply the owner or occupier of that land. And then we have the case of Hill and Tupper, which looks at exclusivity of ownership, of the kind of right to use a canal. So we have Hill being granted the lease of the land on the side of the canal, and the lease gives them the right to put pleasure boats out for hire on the canal. The other party that we see there, Tupper, is the landlord of a local pub, which is also on the canal bank. And Tupper puts boats out on the canal, which interferes with Hill's business. It stops him making as much money and creates a loss of profit. there's then this conflict as to whether there's an easement over the canal in that way for the use of the boats and access of the boats on the canal and exclusivity of such. Hill obviously claiming that his right had been infringed upon and that should be protected as a land right. The courts, however, in this instance felt that it was a personal right towards him and his business, and not sufficiently beneficial to his land, which is a very odd decision to come to if you're thinking about somebody buying or renting business premises. It's obviously only of value if they can utilize it for the purpose which they've bought it or rented out. If they rent it only to run pleasure boats and be the only person running pleasure boats, somebody else coming along and doing that is going to interfere with their business and therefore make the property worth less. But in this case, it was deemed to be, because I think primarily because the person who's infringing on the right isn't the person that they have rented it from. They're just another person who owns a bit of land further up the canal. So because we have to fall down on one side or the other, the courts determined in this case there was no easement here, that it was purely personal, it was benefiting Hill and not benefiting Hill's land, which is an odd scenario to get to, an outcome. However, we have the waters of this significantly muddied by the Regency case in 2017, updated then in 2018 in the Supreme Court. So we have one decision 2017 and then we have 2018 updates. So 2017 allows for some uses that we would not have generally recognised as being sufficient to be easements, because we would have seen them as purely personal prior to that, and then in 2018 it expands it even further. So in the initial case in 2017 we have a claim regarding the use of gardens, tennis courts, squash courts, a putting green, a croquet lawn, a golf course, and then indoor facilities such as a billiard room and a sauna and an indoor pool, as to whether the people who had ability to use the accommodation could then benefit from these other things and acquire them as easements. They were in their contract as recreational facilities to be able to use, thinking then of a contractual license. But we know we can revoke a contractual license and just pay damages. They wanted to be able to have a stronger hold in the land by arguing that these things were easements. Prior to this, these things would never have been seen to be easements because they are purely personal. They benefit the person. But then obviously we would have a situation where somebody is kind of gaining because they are they're adding value to their property because they are able to use it for more purposes than previously. So that adds value, their ability to use these things, gardens, croquet lawns, etc. Those things would add value to something. So we can see that the case in 2017 only recognised the easements pertaining to outside use. So the things that I've mentioned, like tennis courts, squash courts, croquet lawn, golf course, etc., all of those things were recognised as being easements in 2017. In 2018 we go even further, because on appeal, where the internal facilities had not been allowed to be easements because they were seen to be personal, we have an extension there as well. So now we have things like billiard rooms and saunas and indoor swimming pools being allowed to be easements, and that's a very strange position to be in. We have some dissenting judgment there too. So the only kind of way we have as land lawyers to look at this is to think about the list that we already get of what has been recognised as an easement previously and to go from there. So say, for example, with this one, it's relatively easy. We would recognise that the right of way over A's land, over B's land, would benefit A's land. However, who's actually using it? It benefits A's land because A is able to walk in a different way off their land. So it benefits them as a person, really. It's very difficult to look at any of this and consider whether it's personal or land-based. And the only real rule of thumb we've got is that we've got a list of cases that recognise easements previously, and then after regency we can consider others as new easements if we can make a strong argument, it seems. So we'll move into the last requirement before looking at that list of easements. The last requirement being that it has to be capable of forming the subject matter of a grant. What that means is that we would have to have a capable grantor and a grantee, so somebody who's able to give the easement and somebody who's able to receive it. The right itself has to be sufficiently definite and clear. So like I've said before, if it's in relation to a path, we'd have to be able to see it and identify where it is. Parking, obviously see the space, etc. And then there are quantifications for other things like airflow, water and light. The right must be this props up requirement 3 and gives us that ability to extrapolate or analyse outwards. The right must be similar to existing easements. So we look at the list that we've already got and we go from there, really, apparently after regency. And the right itself must not totally exclude the servient owner. So what that means is the dominant party should not take over the servient owner's land. If it was parking, for example, you wouldn't park to the extent that the servient owner couldn't park at all or couldn't use their land. So if we think about the examples of putting those into effect, for the example that I've given for A and B's land, to have capable grantor and grantee, we would have to have had somebody on B's land granting permission to use that right of way to someone on A's land. It would have to be suitably definite, so we would have to be able to articulate where that path is and find it, map it, etc. It would have to be like other easements, which we know, we can tell because a right of way has been considered previously. And that path would have to be contained in a way that A could use it without completely taking over B's land and not being everywhere on B's land, so B could not use it. So those would be the 4 ways of dealing with the Ellenborough Park criteria. You get 4 criteria under there, and that's the stuff that you would analyse or address when dealing with an easements problem question. All that I would really require of you, apart from the formality stuff that we're going to recap in a moment, would be that you're able to support an answer with recognising the type of easement that might be at the heart of your matter, and perhaps supporting that with a case that shows where that has happened previously. So you've got a list there of cases where other easements have been recognised: right of way, a right to light, right to drainage, right to air, a right to store something, and the ability to park. So all of these have been easements that have been previously considered and are very well established. Other things like tennis courts and saunas, etc., is such a weird new anomaly that it's not something that I would put into a registered land problem question anyway. Might have gone into an easements assessment, but that's not what you're facing. So we can move away from essence and think then about how the easement might have been created. We know that an easement could be legal or equitable. However, we've got this proviso in section 1(2)(a) that the easement will only be able to be legal if it looks like a fee simple absolute in possession or a term of years absolute style easement. So is it freely given, or is it fixed in nature for a specific time period or duration? We've covered that before, so I don't feel that that's something we need to go into in any great depth. So if it's a legal easement, it would then require a deed, everything else becoming equitable under section 1(3). So for an easement to be legal, it would have to be unlimited, completely and able to be passed on to somebody else or transferred, or for a fixed period like a tenancy. For it to be legal, then on top of that we would need a deed under section 52, unless it's been implied, which we will look at very briefly, but is not something that you're going to be tasked with. And also then, if it's an express legal deed that has been entered into by two parties, we would require it to be entered into the register. Under section 27, it becomes a legal a registrable disposition, so it has to be entered at land registry. Okay. If equitable, the only requirement would be that it satisfies the conditions for an enforceable contract under section 2 of the Law of Property Miscellaneous Provisions Act 1989, and then it should have notice to protect it at land registry. Otherwise it's only binding between the two parties that have made it. So I said I would touch very briefly on that idea that something could become legal and be implied through continuous use. It's a very old-fashioned and archaic mechanism called prescription that you might have heard of, the fact that somebody acquires the ability to have an easement through their long-standing use of land. So prescription is used for a period long enough to be considered legal. It's a very strange scenario where they figure that if something's been happening long enough, it therefore becomes enabled through law. Some notion that there would have been a deed, it referred to it as the lost modern grant, and that there was a deed but it got lost down the back of a chaise longue somewhere in the 1800s. So it's a very odd notion that somebody might have had a deed but it got lost, so therefore they can carry on doing it because they've been doing it long enough. It's usually acquired after 20 years usage, so we're not looking at hundreds of years here. We're looking for somebody to have been behaving that way for over 20 years and they could acquire the ability to carry on using it. It's referred to as needing these three things: nec vi, nec clam and nec precario. So you're wanting to do it without force, so there is not any force used in order to exercise it. You haven't forced your way onto the land, because otherwise you wouldn't be acting like you're the true owner. So that's nec vi, without force. Nec clam is without secrecy. So you haven't kind of snuck onto the land, because that's not how a true owner would, or the true user of an easement would behave. And nec precario, without permission. That you haven't asked somebody if you can use it, because if it's your legal right to use that easement, then you don't need to ask somebody's permission. If all three have been proven, then that person is recognised as a user as of right. I've talked to you very briefly about the fact that that sort of thing used to happen with actual taking land at adverse possession, but it still exists as in relation to in regards to easements. If you've got somebody behaving that way for over 20 years, they could become an implied legal easement holder. Which means that, as somebody who studied rights of light for a long time, that can mean that just the existence of a building with a window means that they are acquiring that right constantly. They don't need to tell anyone, they don't need to ask anything, they don't need to behave a certain way. They just by the existence of a building and a window, they will acquire that right. The same as the easement of support from another building. Just by having a building that relies on another for support means that after 20 years, that's an acquired right that can't be contested. So I've just given you some examples there that we can think about very briefly. So if you had a right of way for the life of A created by deed, that would not be able to be a legal easement, because for the life of A would not be like a true ownership easement, and it wouldn't be like a term of years easement. So that easement's only going to ever be able to be equitable. A right of way that has been enjoyed for 50 years could be an implied legal easement that has been acquired by someone's long usage. A right to access your tennis club for as long as you're a member, granted by deed with your membership. So that is a real model one that looks very like Regency in terms of using something that's personal but affixing it to land, and then we've got a document too. So apparently after Regency that could be considered to be a legal easement, but it's not able to be legal in this scenario because it says for as long as you are a member. So that would mean that as long as you're a member means it's only able to be equitable, so that deed wouldn't change it. An indefinite right to swim in a neighbour's pool would always have been seen just as a permission or a license or a kindness. Never be never be property rights, never be easements. But again, Regency Villas has muddied the waters for us there. A right to park for 10 years is an easement, because a right to park is an easement and capable of being legal because we've got a definite time period, would then need a deed and to be registered. Okay, so that's some examples and work through. I'm going to keep it quite short today because I know that it's not something that we are assessing, but I want you to get the key bits out of there for your assessment strategy too. Thank you very much.